Good morning. You're Ray No.
Good morning, ma'am. Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
He does, Your Honor.
Just a second. Figure out what today is. Sorry, can you get in there? Mr. No, in cause number 25 DCCR 0386, you're charged with the second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Guilty.
And y'all have marked here aggravated. What is?
Defense counsel put that here.
Yeah, well, they charged it as aggravated with a vehicle, I believe. It was aggravating.
It's just a garden variety intox.
Yeah, I'm going to mark that out because I think that might
Feel free,
have
Judge.
some
Different context.
context at sentencing that you may not want. All right, so it's how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
You're sorry it's going to be a trial.
Sorry, give me just a second to get to the other one. And then in cause number 25 DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 11th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Franklin?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand that it's first of all, it's the way this is written up is that you are pleading open to the court. There's no agreement. Is that correct?
Yes, Your Honor.
And so you guys, a couple things. I need the other one sent back. So is it on the trial court certification of defendant's right to appeal? On this case, the state jail, the admonishments were signed saying that they're waiving the right to appeal. And then on the certification, it's actually 2 of them were checked off. One is the defendant has waived the right of appeal, and the other is it's not a plea agreement and the defendant has a right to appeal.
It's not a plea agreement,
Right.
so that's correct.
Okay. So with everyone's permission, then I'm going to erase the check mark on the defendant has waived the right of appeal because it's not a plea, so he will have some right to appeal.
Yes, Your Honor.
No objection.
Also, on each of the paperworks on the post-conviction waivers that you both signed, I will mark that out as well because that's saying that he's waiving his right to appeal.
Yes, Your Honor.
No
Okay.
objection.
All right, thanks. So,
Your Honor, I would note too, I think I had a few stray, I'm a left-hander. I think there's a few other stray marks on there that I
Okay.
tried to erase and wasn't able to. So
Gotcha.
if you see those, I apologize.
gotcha. We
my hand,
we
perhaps.
understand the left-handed issues up here. Ms. Werner feels your pain on that. Okay, so I want to make sure you understand a couple of things. You have an absolute right to have a jury come in and determine 2 things in these cases. The first would be to determine if you're guilty or not. And then the second would be if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me in each of these cases. And is that what you want to do?
Yes, Your Honor.
All right, state tenders number 1 in each case.
No objection, Your Honor.
It's admitted. Also, sir, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
All right. Is there any evidence that Mr. No is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for a sentencing hearing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Obviously, if there's anything important that you want me to know, get that information to Mr. Franklin. He will present it to me on your behalf when we come back. Do you guys anticipate a little bit of extra time on this one as far as witnesses or argument,
Just brief, not much.
but a little more than normal?
Yes, Your Honor.
Okay, so if I were to set it at 11 on a docket date, we could, maybe an hour would be enough? Or do you
Yes,
think
Your
we
Honor. I
need
think an hour.
Okay, all right, so we'll reset it for sentencing and we'll just do it at the end of a docket so you don't have to sit and wait unless you have some other cases. You need to stop and talk to probation on your way out of the courtroom and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing. Thank you.
Thank you, Judge.
Mr. Smith, there you go. Good morning. Good morning, sir. You're Brandon Broussard? And Mr. Broussard, this is cause number 24, DCCR 1150. And in that case, you're charged with aggravated assault causing serious bodily injury from April 20th of 2024. This was a final reset. The state was going to subpoena the complaining witness, Mr. Smith.
We did, we would call Lanielle Brianna Briggs.
Lanielle Brianna Briggs.
No response, Your Honor.
Judge, we have sent a subpoena to Ms. Briggs for this case to be here. She's not appeared, she's not contacted our office. We sent it both certified and regular mail. We've not received anything back. So this time we would follow dismissal against Mr. Broussard.
All right, I will sign that. Mr. Broussard, are you and Ms. Briggs still in a relationship? Okay. Obviously, whatever went on wasn't a good thing. The case is getting dismissed today. My suggestion is to stay away from her so that there's no other issues in the future, all right? You're free to go, sir. Mr. Galmore, you have Andrew Pickerel. Good morning, you're Andrew Pickerel.
Good morning, yes.
And so, Mr. Pickerel, this is 24 DCCR 2480, charged with fraudulent use or possession of identifying information. Before we go any further, I have represented Mr. Pickerel in the past when I was practicing. I don't know if that's an issue for anyone. There's probably some information, not with regard to this case, but just some other incidents where there's some information that I know just based on some other relationships as well and friendships. You guys might want to go visit real quick about that and let me know if y'all want to waive any conflict or if you want to stay. If you want to visit in the back, I'd be glad to visit about it as well.
Okay.
All right, so I'll just hold it for a few minutes. Good morning, sir. You're James Rucker?
Yes, ma'am.
All right, Mr. Rucker's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, the state would like a reset. I know this is unusual for the state to be asking for a reset, but there's some information the defense has that the state would like to see. And there's been some other events that have occurred that the state doesn't feel like moving forward with this for a trial is appropriate at this time. But by next month, it will either be a trial or a dismissal.
So, obviously, I guess you're okay with that. You have
We're
some,
fine with that, Judge.
what I'd like to do then, if this information could potentially be dispositive one way or the other, is I'd like to go ahead, let's get it off the trial docket. I'll just put it on a review or status hearing. If something happens and the case is dismissed, obviously we'll take care of it. If not, it'll go right back on the trial docket. It's not going to delay it very much. Okay, so I'll just do a normal 30-day reset to a just a status type docket. Stay in touch with Mr. Galmore. He'll let you know when you need to be back. Okay, thank you, sir. You're free to go. All right, ma'am, you are Ashley Broussard. And Ms. Broussard's case in cause number 25 DCCR 0175 is set for jury selection to begin next Monday. And what is the announcement?
Great. Just for the record, Your Honor, she has refused to defer an offer for probation.
Okay.
Stay
And
ready, Judge.
so let me look real quick. What is that, a new offer that was relayed today, or she's
That's
already
what she
done that?
rejected back in June of last year.
Okay, so Ms. Broussard, your case is set for trial for next week. There will not be any plea agreements after today. Do you understand? And you want to go forward with your trial. All right, so I will number the cases tomorrow after the docket. Stay in touch with Mr. Kimmler, and he will let you know the trial order, but we'll see you likely next Monday, okay? All right, you're free to go. Good morning. Are you Remington Boykin? And Mr. Boykin is charged with tampering with a governmental record in cause number 25 DCCR 0396. And Mr. Gertz, what is the announcement?
Judge, we're working through discovery on this. He has a pending case in Hardin County as well that we're working through. In an ideal world, we might be able to get some kind of global deal done, but we're not anywhere near that yet. So this is the, I would say, less aggressive of the cases that he's facing right now. So
You do know that I'm not going to wait on Hardin
I know
County.
that you're not going to wait on Hardin County, but I'm asking for a little
Okay.
bit of leash because
Yes.
of that. If I could have it, please.
Any issues?
Not on this case, Your Honor.
All right, we'll do a normal reset. Mr. Boykin, make sure you stay in touch with Mr. Gertz. He'll let you know when your next court date is. You're free to go. Chad Cracknell.
You don't want to stand there, Mike.
Good morning, Mr. Jamel. That could be fun.
That's the, yeah. Raise your
Please,
right hand,
please
Mike.
raise your right hand.
Yes.
All right, are you Chad Cracknell? Mr. Cracknell's case is set for trial to begin with jury selection next Monday. I have a feeling I know the
Yes.
issue.
I will tell you, I got, and I don't know if something's changed because Mr. Nichols is standing here, but I got an indication from Mr. Hoffpower before the holiday that there might be something new in the pipe for resolving this case, but I don't know what it is. It was just kind of a
Is he
passing
upstairs?
comment.
He is, and I asked him earlier if he knew it was, he said that he thought they might be able to work it out. I think they just need to talk.
Yeah. And
So that's the time to do that's before today.
sure. No question, but I think I got an indication from him that he had something new but didn't have it ready, and I just haven't heard from him about what that would be. So
Can you
I'm-
ask him if he can run down real quick and
Yeah,
just
sure.
give us a
I
status
sure
on that
will.
one? Let me hold it for a
'Cause
minute. So
it's-
I want to make sure we're,
It's something we would be willing to resolve, as you
Right.
know, what
Sure.
the issues are in this case. But
Okay.
But I got the sense that it would, if it changed materially where we were talking about, that could potentially give us a resolution.
all right, so let me hold it and we'll get him
If you
to
don't
come
mind.
down just for a sec. I know he's getting ready for trial, but we'll get him to come down just for a minute and see if there's something that you guys can visit with quickly. If not, maybe we'll just do a couple of weeks or
Okay,
something.
thank you, Judge.
If y'all can just have a seat for a few minutes. Thank you. Good morning, you're Jaron Crane. And Mr. Crane has 23 DCCR 1082 charged with evading arrest or detention with the use of a vehicle. 23 DCCR 1406 charged with aggravated robbery. And 23 DCCR 2233 also charged with aggravated robbery. What is the announcement?
Judge, we took over this case from Mr. Lewis and
Let's see that.
I think mid-November or something to that effect. So we'd asked for one resetting so I can meet with Mr. Crane and talk with him about the discovery and the allegations and discuss also with Ms. Malfino a potential resolution.
Ms.
And
Malfino?
Judge, if you will recall, the co-defendant, Mr. St. Clair, in this case, we've gone back and forth. In light of new counsel now on board, I'd like to have the opportunity and ask the court's permission to revisit the issues that came up with Mr. Lewis to see where that puts me in the position with Mr. St. Clair, so I'm not in objection to any reset.
So I'll do a normal reset, and I know that you are new to the case, newer to the case, but the cases are
It ain't new.
very old.
I gotcha.
And so I'm going to kind of hold you to a little different standard on this one, just because it's time for everybody to figure where we are on
And I've
these.
also reached out over the holiday to Mr. West, reiterating a discovery compliance certificate, et cetera, and inviting him for the opportunity to maybe sit down and talk about that one last time in light of Mr. Bird's now being involved.
Okay.
And so I will do my best to try to wrap up, that would be about 7 or 8 cases. all
Sure.
at once.
Okay, sounds good. We'll just do normal reset and see where we get. Stay in touch with Mr. Gertz. You'll need to visit with him once he gets everything he needs from the Assistant District Attorney before that next court date. All right, you're free to go. Good morning. You're Larry Fletcher?
Yes, ma'am.
And Mr. Fletcher has 3 cases. He has a motion to revoke his probation, and then 2 new cases, cause numbers 25 DCCR 0839, a manslaughter case, and 25 DCCR 0838, an assault, aggravated assault with a deadly weapon. And what is the, so there was we were here at one point, and he entered pleas of not true in the motion to revoke probation. And it was, I guess, kind of reset for sentencing, but with those new cases, what,
Your Honor, with the court's permission, the state would like to proceed on the MTRP first.
Judge Matt, if we're gonna do that, I'd ask the court for 2 weeks. to do
no,
that.
we're not doing that today. I mean, because
No, okay, I'm sorry.
no, I'm not inclined, so, okay, here's the thing. Typically, the way I'll handle motion to revoke in new cases, if the new cases are, I don't want to have to hear it all twice. So if it's a new case and it's a witness or 2, that's one thing, especially if it's a lesser offense. With these types of offenses, would typically be more inclined to hold the motion while we take care of the other cases.
The state's thinking, Judge, is depending on the outcome of the MTRP, I think that would be dispositive potentially of the other cases without the necessity of having to pick a jury and go through the jury trial. But that's just the state's preference too. I
Right.
understand the court's decision.
No, and I'm not saying I'm opposed to it, I'm trying to, so this underlying offense that he's on probation for is a 2nd-degree felony. So what would it would be proving up the aggravated assault and the criminally negligent homicide?
That's part of it, yes, ma'am.
Time frame on that type of hearing?
Wouldn't be extensive, Judge. No more than a day. No more than a day. That's probably at the high end.
Okay. All right, so he's already entered the pleas of not true. So I'm going to kind of grant what Mr. Coleman is requesting on this one.
If it's essentially, and I'm not complaining about it, Mr. Coleman has the right to do whatever he wants here, but if it's essentially gonna be miniature trials, then I would ask the court for some time.
Sure. No, so what I'm going to do is reset it for sentencing. Obviously, I need to find a day. Probably going to be 45 to 60 days out. Obviously, I know that might be quick to get ready for a trial, but I think you should already have
We're working through the discovery.
the discovery.
Yes.
Is there anything you're waiting on, anything that's pending, outstanding?
Yeah, I'm not aware of it, but he's saying no, so then. my
So
answer would be no.
because we're going to do it this way, let's do about 60 days, and then we'll look and find a day on a week where we do not have a trial, and I'll give you guys at least a day. On those weeks, we can even have a little bit more. All right? Okay, we'll see you back. And I guess you can just make a note in the memo. Good morning, ma'am. You're Kelly McBride?
Yes, ma'am.
This is 25 DCCR 0044. Ms. McBride is charged with obstruction or retaliation. And Mr. Samuel, what is the announcement?
Your Honor, we have something worked out, but I was just hired on, down the hall. I went down, we have something, we're gonna get that. So we're asking for one additional reset. Well, I believe we'll have it resolved.
Okay, any
And I
issue?
have no issue with that, Judge. We have made an offer to resolve the DWI down the hall, which then allows me to make the probation offer that I didn't make it. It should wrap it all up.
So this will be the last reset. Make sure you stay in touch with Mr. Samuel, take care of everything you need to down the hall, and then we'll get the case taken care of at the next court date. So I can put it on a plea docket. It'll be
Yes.
taken care of. All right, we'll
Yes.
reset it to a plea docket then.
Thank you, Judge.
Thank you. You're free to go, ma'am. Thank you, you too. Good morning, sir. You're Clayton Friddle.
Yes, ma'am.
And Mr. Friddle's cases in cause number 25 DCCR 0450, 0451, and 0452, all charged with official oppression. And Mr. Gertz, what is the announcement?
Judge, still working through these. I think we can have a real answer in 30 days. If we can have 30 minutes.
Mr. Smith, any issues? This will be the last, looks like you filed your letter of rep at the end of April. So this will be the final reset. Make sure you get in to visit with Mr. Gertz before that next court date so that we know what we're going to take care of, how to take care of your cases. Okay? All right. Thank you. You're free to go. All right, did you get that last? Good morning, sir. You're Dustin Knight. And so is this a re-indictment or is it two cases?
It's a re-indictment, Judge.
All right. Can
It
we
just changed the language. We've discussed it. It's
We're
the
agreed.
same charge. it's
Sure.
just a
You can
cleaner
just,
change in the
if
language.
you don't mind getting that other one dismissed, now that it's been indicted, that'll clean up
Okay.
what I'm looking at as well. And sir, you're Dustin Knight, and Mr. Knight is charged with collision involving death. Case set for trial to begin with jury selection next Monday. Mr. Gertz and Ms. Molfino contacted me Friday. I know Mr. Gertz has two different things going on that seem to take precedence over this case, which is unfortunate because of the age of the case. Obviously, everybody knows that I'm ready to get it tried. I know that the complaining witnesses and victims' family are obviously ready to get this tried as well.
And
It
I
has their-
spoken with them
have you?
about those issues, Judge, yes.
Okay.
You know, they're very understanding. We talked through them when Mr. Gertz and I spoke as well. I have also filed, and I'm sorry to interrupt.
No,
just
I'm glad
put all
you,
this on
no,
the
please
record.
do.
I've also filed numerous documents in this case that was brought to my attention this morning. They did not go through the e-file. They've been e-filed, but they didn't process, I guess, because of the holidays. So
Mhm.
I anticipate, I've shared what I filed with Mr.
Okay.
Gertz as well, and I anticipate there'll be more things for the court to address in signing those, but I don't foresee any reason we couldn't be ready for trial very shortly.
So, Mr. Gertz, has there been any change that you know of with regard to either of those? I know you've got a
Judge,
case
I would-
next door with Judge Stevens, and then also Judge Thomas has a
My answer is.
protective
I would
order,
be-
right?
He does, Judge.
protection. Okay.
I would love to tell you yes, but I can't.
Okay. So just so that because of the nature of this offense and the witnesses and everything, I'm going to go ahead and reset it today. And then we will get it set on the next available trial docket. Make sure you stay in touch with Mr. Gertz. If anything changes between now and then, y'all let me know. Obviously, I'll take a look at whatever comes through. And if there's something we need to do before the next court date, legally or whatever, then we'll take care of that as well.
I don't anticipate that, Judge, but
Okay.
with the court's permission, before Ms. Holmes sets it on a docket, would you mind if I reach out to the family just to check their schedule, just kind of, I need to try to work around the kids, the young kids' spring break, and also the wife of the decedent
Sure.
is taking a full load at Lamar right now, and so she just asked me kind of to be cautious of the dates so that she can work around some stuff.
Yeah. So if you'll just make sure, we'll talk about it and get with Ashley on that. Okay, we'll take care of that.
Okay, thank you.
Thank you. All right, you're free to go. Good morning, sir. You're Miguel Martinez. And this is 25 DCCR 0584. Mr. Martinez is charged with aggravated sexual assault of a child. Mr. Gertz, what is the announcement?
Judge, we're still working through the discovery in this case. I don't know exactly when it was indicted, but this may be our first or second appearance, so.
Looks like you filed your letter of rep June 3rd. So,
It's longer than I thought.
yep. Any issue with the reset?
Nothing that we're aware of, Your Honor, so no problem with the reset.
So we're getting close to that time on this one, so I'll do a reset. Mr. Martinez, make sure you stay in touch with Mr. Gertz so you guys can go over the case, and we'll see if we get an announcement at the next court date, okay? You're free to go. We're
You want
here.
some background or?
Yeah, so, well, it looks like we're here on a motion for early termination.
Yes, Judge.
Let me look at this. So Mr. Rogers is on probation for two cases. In cause number 20-34772, on probation for aggravated assault with a deadly weapon. Was placed on was a 10-year deferred, is that correct?
That's correct.
October 26th of 2020.
Yes, ma'am.
And then, oh, thank you. And then in cause number 20-34493 on probation for aggravated assault causing serious bodily injury, same thing, deferred probation for 10 years on probation from the same date of October 26th of 2020 is the date of that probation, correct?
Correct, Judge.
And Mr. Gertz has filed motions in each of those cases for early termination.
Judge, I know typically this is something that you reach out to us in advance and just get our input on it. I just wanted it to be on the record due to the nature of the offense. I've spoken with his probation officer, and I don't believe she has any issue with an early termination. He
I don't-
also successfully completed Veterans Court and has done very well. I just was hesitant due to the nature of his offense.
So my issue with this, and I did get Ms. Malfino's response when I sent it to her. The judicial clemency part is my issue, based on the nature of the offenses.
It's deferred or is it straight?
It's deferred.
It's deferred, so judicial clemency wouldn't be, did I write judicial?
You
clemency?
did.
Oh, well, you don't need to grant judicial clemency because he doesn't have a conviction.
Right, that's what
And
I,
I think that was an issue I wanted.
yeah, I definitely did not.
I'm
I
sorry, so
definitely
that
do-
was just a holdover, I think, that I just didn't notice in our filing, so I apologize. So sometimes that comes up, but only with a conviction case, Judge, and these are
Right.
both deferreds. So judicial clemency shouldn't be an issue.
I did also, for the record, get a response from probation from Ms. Martinez that states that pretty much what Ms. Malfino stated, that he successfully completed the veterans program, completed anger management, that he has done well. They just, due to the nature of the offenses, aren't going to make that recommendation and would defer to the court, but are not opposed to it. And that's the position of the state as well. Then at this time, I will grant the motion for early termination of community supervision in each of those cases.
This is one of the more positive moments of the entire docket. Early termination of probation isn't automatic. A defendant must demonstrate long-term compliance, complete required programs, avoid new violations, and convince both probation officers and the court that continued supervision is no longer necessary. Even with serious underlying offenses, the judge focuses on performance during supervision rather than simply the original allegations. The message here is clear. When someone follows the rules, completes treatment requirements, and stays on the right path, the justice system can reward that progress. It's a rare example of a success story in a courtroom often filled with setbacks.
A little over half of your probation period, so you're entitled to early termination if you've done certain things. This is the type of case where I'm glad to be able to say that you've done it all, and you, I'm signing the order today, so you will be off probation. All right, good luck to you. Thank you. This is Ms. Malfino. Oh, she's right there. She's coming. It's all good. Good morning. You're Ryan Hodge. And Mr. Kimler, will your client waive the formal reading of the indictment?
So waived.
And we're going on the full indictment, correct? Mr. Hodge, in cause number 24, DCCR 1167, you're charged with third-degree felony offense of evading arrest or detention with the use of a vehicle from April 11th of 2024. Your indictment further alleges that you were previously convicted of burglary, a second-degree felony, May 12th of 2015 in Grady County, Oklahoma, and on that same date, also convicted of possession of a controlled substance in Grady County, Oklahoma. And then after those were final, you were convicted March 20th of 2018, also in Grady County, Oklahoma, of bribing an officer, and on that same date convicted of a felon in possession of a firearm in Grady County. How do you plead to that charge? So how do you plead to the original charge that you're evading arrest or detention with the use of a vehicle? And are those prior convictions true? Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And so, is there a fine agreed to?
I marked a fine. I would look that up to the state.
500 is fine.
So it looks like the agreement that you've reached with the district attorney is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? I want to make sure you understand that because you've entered a plea of true to all of those prior felony convictions, that this is a little different than a normal 10-year deferred. If you violate, your minimum punishment by law that I could give you if you violate this probation is 25 years, non-negotiable, because you've pled to it this way. If you violate, the minimum is 25. Do you understand?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Hodge is not competent?
None that I'm aware of, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing. Do you have your discovery certification?
Yeah,
Okay. Go
May
ahead.
I inquire if he has a GPS, Judge? I know he resides in Oklahoma. I don't know if that would be something that,
Was it part of your bond that you have a GPS monitoring device?
Yes, they have.
So are you wearing that
Yeah,
now?
yeah, they have.
Okay.
you have it on you right now.
No, they've taken it off, like, since prior. I had a problem with it, but I came down there and I've been checking in twice a week. They've changed the stipulation of it, but
So
they
what-
said as long as they changed.
It might have been, so your bondsman had that condition on you?
Yes.
Not the court? Okay.
Yes, but she said you've been following up and going to court, everything's been good.
Okay. All right, so it's very important. Obviously, today, stop and talk to probation. She's going to let you know what you need to do. You're going to need to go to the probation department before you leave. You're going to have to set up that appointment for that pre-sentence report. If for some reason you don't do that and you don't follow through, then you run the risk of me not accepting the plea agreement. Obviously, things could be much worse. If you're arrested for anything between now and when you come back for sentencing, obviously, I'm not going to accept the plea agreement. Things can be a whole lot worse. Do you understand? All right, stop and talk to probation. We'll see you at sentencing. Ms. Nguyen, in cause number 24 DCCR 1298, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And so is the agreement, it looks like, for a 12-month term in the state jail prison?
Yes, Your Honor.
Yes,
She
Judge.
has 11 months
Okay.
of back time.
Okay,
So she would have to serve one more month.
okay.
The defense is requesting if she could turn herself in on Friday. She has 3 children that she needs to get situated.
Well, so what we need to do is, I'll go through with the plea, but not sentence her, because if I sentence her, it just turns into an issue if she doesn't.
Okay.
The motions for new trial and things like that, there's really not a lot of things we can do. So, I can take the plea today. We can do the sentencing Friday. We can do the sentencing Monday during the next docket.
Okay.
I'm willing to do the week, whatever.
Couple of things, Judge. If we can maybe put on the record how we arrived at that time. And also, there's the state, well, ordinarily, I wouldn't be opposed to a defendant turning himself in at a later date. This plea was contemplated prior to today. In other words, this defendant knew that there was a very good chance that she would be going the other day. On its face, it just looks like a plain Jane state jail felony theft, but judge, it appears that she may have been a part of a theft ring that committed more than about 29 total different crimes to the tune of about $50,000, Judge. So with all that being said, I'm not so amenable to her turning herself in later, but of course that's up to the court.
So here's what we'll do. We'll go through with the plea, and then we'll be here and do sentencing this Friday at 9 a.m.
Yes, ma'am.
Can you do that?
I have municipal court Friday morning, but.
What time?
We typically start at 8:30. But I could,
I mean, it won't take long.
yeah, I can tell them I'll need to leave and come and go back.
I mean, we can do this at 8:30, and then you can just, instead of starting and stopping, and just be, I mean, it'll
Little
take
late,
10
yeah.
minutes.
Okay,
Would you rather that?
Yeah, that's
Instead of starting and stopping, just let them know you'll be a little bit late?
yes, that's fine.
Okay, so that's what we'll do then. All right, so, and you guys have talked to the clerk about the credit?
Yes, so there were several counties, in which Ms. Wayne was transferred throughout, from 2024 to 2025.
For various thefts.
Okay.
Yes, from various thefts in various counties. So we have, we know that Jefferson County put the hold on her in June of 2024,
Okay,
and then she was released in May of 2025,
okay,
after completing all those other counties.
okay,
Yes, ma'am.
gotcha. All right, so is that your understanding of the agreement?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to this Friday, which is January the 9th, thank you, at 8:30 a.m. It's very important that you're here on time because Ms. Holmes has something else she needs to do in another court. And so we'll all be here early. We'll get your case taken care of. You'll go into custody. If you don't show up this Friday, well, just let me go. Good, I hope so. But let me just, if you don't, then I don't have to accept this plea agreement and things could be worse. You understand? Also, if you're arrested for anything this week between now and when you come back Friday, you run the risk of me not accepting that agreement. You understand? And it sounds like there's the hold, there's some documentation of the hold that we had. And so the credit from that June date in 2024 to the release date in May will be granted as far as back time.
Today's docket showcased nearly every side of the criminal justice system. We saw guilty pleas entered, cases dismissed, trial settings postponed, probation matters reviewed, and even an early termination granted for a defendant who successfully completed years of supervision. The most significant case involved an intoxication manslaughter plea, where the judge accepted the guilty plea but delayed sentencing until a full pre-sentence investigation could be completed. Throughout the hearing, the court repeatedly emphasized accountability, preparation, and making decisions based on complete information rather than rushing to judgment. Cases like these remind us that every courtroom appearance can dramatically affect a person's future. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.